Next week, maybe, please.
May please, Your Lordships.
Yes.
The matter listed for the first time, but I have filed an application, my lord, for interim bail. And I am supported, my lord, by a judgment of this honorable court that an interim bail, my lord, can be filed even while awaiting notice on service of a victim. But I don't know if the learned public prosecutor will intimate to this honorable court if the victim has been intimated. I wanted to make a limited submission for interim protection whenever the matter can be taken up.
The victim has to be intimated here.
Yes.
According to instruction given by the IO, morning itself, they given the victim father and mother.
Intimation has been given.
Father and mother.
But I will now make a limited submission for the purpose of interim protection, and I'll try to satisfy my lord that it can be granted even while awaiting.
Yes.
Appearing for the victim and not. Just in the morning, I've been told that such an application has been moved by them. Therefore, I request your lordships to kindly request them to serve public prosecutors serve the papers to me. Probably your lordship can I hear it next week?
No, my lord, I have one request. Lord, I'm grateful my friend is appearing. I'll immediately serve him papers. Matters will have to be heard in their presence. I concede, my lord. But my lord, your lordships always have a power that while your lordships would await for the victim to render proper assistance to the court, this matter in terms of an interim arrangement can always be considered by the court. I will satisfy your lordships, my lord, with one or two judgments. Lordships may just hear me on the requirement of an interim protection.
My lord, my respectful submission is.
No, I'm not going to grant any order without hearing you. Don't worry about it. Yes.
Yes. My lord, matter arising under, my lord, the provisions of BNS and POXO. But I must satisfy this honorable court that while, my lord, the victim would have to be heard when, my lord, whenever they are going to assist your lordships, I am entitled for an interim protection. But I am in an anticipatory bail. I am not asking for quashing of this particular matter. My lord, my case is very simple. Lord, if your lordships were to look at that particular complaint in relation to which, my lord, I am seeking interim protection. But my first submission for your lordships would be that the complaint on its own terms would make out, my lord, mitigating circumstances, my lord, as several courts have held, for the purpose of granting me interim protection. But eventually, because today your lordships are not hearing the anticipatory bail grant or rejection, my effort will be to show to your lordships a very limited point, which is this matter would have to be heard at the request made by the victim, my lord. The PP also may want to assist, lord, at a particular date. Do I make out a case for grant of an interim protection in the particular meantime? Lord, lordships will hear two objections, Lord, so let me meet with them straight away. Lord, one objection that I foresee possibly coming from them is this honorable court is being approached directly without approaching the sessions court. Lord, I'll place two Supreme Court judgments, Lord, which are categorically stated. It's a concurrent jurisdiction. We can approach this honorable court directly. Lord, once it is a concurrent jurisdiction, that objection, my lord, in my respectful submission may not have much teeth, but what I will do is I'll preserve my breath. I will deal with this if they make this particular argument, but I'm supported at least by two Supreme Court judgments. My lord, the second objection, my lord, that they would say is about notice to victim. My lord, victim has been intimated. My lord, there's a counsel appearing. As I said, my lord, while lordships would hear the anticipatory bail after hearing the victim, I'm entitled to make some submissions. My lord, very quickly I'll move, my lord, to the points I want to make for your lordship's consideration. My lord, an offence under POXO, no doubt, my lord, is treated as a grave offence. But, my lord, legislatively, my lord, they have ensured that there is no bar against grant of an anticipatory bail. But I'm making an argument only for interim protection till my anticipatory bail is to be considered. If I'm able to satisfy...
So what is the interim protection that you're asking?
But I'm asking that I should not be arrested by the police because I want to assist the police, my lord, till your lordships hears the anticipatory bail, whichever date, including tomorrow. Since your lordships have indicated your lordships are sitting tomorrow, I'm here to assist your lordships even tomorrow. Let them not affect arrest, my lord, because this person wants to go join investigation and show some material. It will take me 15 to 20 minutes to show to your lordships that I have a case, my lord, that I will be able to make out before the police for the purpose of satisfying the police and the investigation team that this complaint made against me is completely false and is frivolous. It would not come within the meaning of, my lord, the offences under POXO. I will show your lordships a few judgments, but within this 15 to 20 minutes only for the purpose of satisfying this honorable court, that my anticipatory bail deserves, my lord, a proper hearing by this honorable court. If it deserves a proper hearing, in the meantime, if I don't have an interim protection, the police, my lord, they have indicated they are already trying to take me into custody. If they take me into custody, my lord, my anticipatory bail will become infructuous. If they are ready to argue today, I'm ready to argue my anticipatory bail. But I concede that they cannot be subjected to this discomfort.
Why POXO will not apply to you?
Two submissions. My lord, first, But I'll make the case at a higher level. Even if POXO were to apply to me, my lord, the interim protection can be granted, my lord, are settled judgments of this honorable court in certain mitigating circumstances. I will be showing to your lordships, my lord, that I clearly come within those exceptions and those mitigating circumstances where an interim protection must be granted to me, and maybe I'm entitled to the grant of an anticipatory bail. Lordships, just gives me 5 or 10 minutes, my lord, I'll just set out my case very quickly. First submission, my lord, for your lordship's kind consideration. This will I'll argue more elaborately when your lordships hear the anticipatory bail, is there is no bar against grant of an anticipatory bail under POXO. Unlike, my lord, SC/ST Act. My lord, when the legislation wanted to forbid, my lord, the even consideration of an anticipatory bail, it legislatively provided so, which means, my lord, the legislature did not want to bar the applicability of 482 BNSS, old 438, in relation to a crime registered in relation to POXO. Which means, my lord, that even while the legislature, and my lord, now several courts have been behoving, my lord, the legislature for the purpose of making some amendments, but even when the law was made in the most stringent form, the parliament did not think it has to be so stringent that an anticipatory bail should not be maintainable or should be barred, unlike SC/ST Act. So, my lord, in law, anticipatory bail I'm entitled to file, and the court, my lord, would consider on its own merits. My lord, second, my lord, the courts have clarified that the presumption under section 29, my lord, which is presumption when an allegation is made that this offence under POXO has been committed. But now several judgments, and I show only one judgment which covers all these judgments, specifically say presumption applies only after charges are framed. It does not apply at the stage, my lord, your lordships are considering bail or the grant of anticipatory bail. So there is no presumption and there is no bar against consideration of anticipatory bail. My lord, then what would be the parameters that would apply in relation to the grant of an anticipatory bail? My lord, which are arguments, as I say, which, my lord, I may have to make tomorrow or whenever your lordships are inclined to hear the matter. The parameters would be the regular parameters, my lord, of an anticipatory bail in relation to any IPC offence, my lord, which is now BNS offence, which would be, my lord, the relevant standards in relation to an anticipatory bail, my lord, Gurubaksh Singh, Siddharam Sethalinga Maitre, my lord, and also, my lord, the latest judgment of Sushila Agarwal, 5 judges. Whatever your lordships consider for grant of anticipatory bail in respect of a regular criminal offence, same parameters would apply in relation to the grant of an anticipatory bail also. But one special feature in POXO, which, my lord, judicially has been carved out, is it would matter a great deal to see the conduct of either party. The conduct of the victim, the conduct of the accused, and, my lord, another feature that your lordships have now read into in POXO, my lord, your lordships have recognized that POXO was originally brought in for the purpose of preventing exploitation of children, but people in a position of authority, including relatives or my lord, any person having any kind of authority. It could be a teacher, it could be anybody having control of the children. They were, my lord, unfairly exploiting the children, my lord, for several, my lord, immoral purposes. The law was intended to curb that particular mischief. But there was always a separate offence in relation to, my lord, a sexual harassment. There was always a separate offence in relation to, my lord, an allegation that may constitute rape in a particular matter. It needed that extra feature that this has to be a child, my lord, who is of such defenseless capability, because, my lord, the child is very young. It needs, my lord, someone exerting influence to do it. The point, my lord, that your lordships have set down, but I know, my lord, your lordships are under tremendous pressure. I'll try to be as quick. But, my lord, the point that your lordships have finally settled upon is, in relation to POXO, if a child is above 16, some high courts say, some high courts, my lord, say it can even be 15. If 15 to 16 to 18 is the age in which the victim is, it would still be a case of POXO if a case of POXO is made out. But there, my lord, the conduct of the victim becomes extremely relevant. Your lordships have said that would be a mitigating factor at the bail stage itself, not at a trial and conviction stage. So, my lord, in these parameters, that I want to place the complaint for your lordships for the purpose of making an argument that till whenever your lordships are going to hear this anticipatory bail, I am entitled to the grant of protection. Now, would my lords kindly have the complaint filed, my lord, which is FIR starts at page 13. The complaint itself starts, my lord, at page 16.
16.
16, 1 6. my lord, I just
Yes.
wanted to make one request. I understand, my lord, your lordships already got delayed in the division bench. I'm here the whole day. If your lordships would want to, my lord, only thing is because I'm asking for interim protection. I can take, my lord, the next 15-20 minutes. If your lordships want to take it up before your lordships rise, I'll wait so that, my lord, the other advocates also need not wait.
We'll
Because
take up tomorrow. If
no,
you
my
are-
lord, tomorrow, my lord,
I need some time because
then let me make out my case. Then let me make
what
out my
I can
case.
see is there are no 161 statements. 164 statements seems to have been recorded today. That will also come out. And in the original complaint, there are several details which the girl has not mentioned. And she has gone to the extent of saying that section 511 attracts, which is punishable at 20 years or life.
My
And in
lord,
such a
then let
situation,
me.
is it
My lord, I'm
appropriate
sorry.
for us to
My lord,
even hear
if my
an
friend has
advocate
instructions
application?
to argue, he
And
can
even
argue.
without going to
My
the
lord, if
lower court,
I'm sorry, my lord, my learned friend may not.
may not be appropriate. My respectful submission is kindly grant me some time, a week's time. I'll file detailed counter. Your lordship may hear the matter at length.
My lord, then
Not
let
any
me.
interim
fair enough,
protection. It is the interim protection is as equal to an anticipated bail application.
Then let
What
me-
is
let
so
me
new
make out
about
a case.
it?
So
It
what
is
is
not
there,
different.
see, you have to make out that it's either not a FOCSO case. Okay, you have made the advanced argument saying that about the maintainability of the bail petition here without going to the trial lower court.
Yes.
And also that this court can grant bail even in FOCSO cases. These are the two arguments made by you.
Correct.
But my question is, if it is, you seem to have said that she is not a child or below the age of 18.
In my bail
So,
petition, I've said.
in the bail
Yes, ma'am.
petition, you have said. So, are you trying to make out that this is not a FOCSO case at all? If that is so, come directly to the point where you have any evidence that she is not, she is more than 18 years
Yes,
of
ma'am.
age.
My lord, if I may just show that this is something that will require, my lord, this honorable court to consider. My lord,
And
there
then you
was
also
an
will have
FIR
to
registered.
No, and you will also have to satisfy that how we are different and why should any interim protection be granted to you?
Yes.
How we are different from any other accused?
But I am,
Because the same courtesies are not being extended to everybody.
my lord,
You should show what is that urgency in your case
Yes.
that you should be granted this.
my lord, may I deal with in the reverse order. My lord. That is
Yes,
most
come.
important. What your lordships asked. I am no different from anyone.
Then,
But I'm entitled to, my lord, seek your lordship's indulgence as, my lord, any other person who, my lord, can come before this honorable court and make a request. But today, whenever I'm making a request today, and your lordships would see every of my argument, my lord, will be steeped upon any common man approaching this honorable court and making a request. And I'll be referring to, my lord, judgments of this of various courts, my lord, which only refer to cases made out by, my lord, ordinary citizens of India in respect of whom protection has been granted. So, my lord, first I want to dispel, my lord, any impression that there is anything important about this person. No, I'm sorry. But there's absolutely nothing important. There is nothing special. My lord, this person is as common as any other person. So, my lord, I have not made any submission.
so what are the circumstances? Why do you need that interim protection
Yes,
now?
ma'am. Now, two submissions. But if I may just indicate what my arguments are going to be. My lord, the courts have said that in a POCSO case, my lord, the entire POCSO case itself is predicated on the age of a victim. My lord, I will make my arguments at two levels. First argument for your lordship's kind consideration is, in a charge sheet filed by the police in relation to the victim in an earlier instance, my lord, the police had identified the age of this victim about 5 years back as 15 years. If the police charge sheet is correct, and if the police were to be correct, my lord, in the charge sheet, for an underage driving, some case was registered and a charge sheet has come to be filed against the father of the victim, showing the victim's age, my lord, at that particular point of time as 15 years driving a car. So the father, my lord, obviously child can't be prosecuted. The father was, my lord, charged. If the charge sheet, and your lordship, my lord, will proceed on the basis is not an FIR, a charge sheet that was filed, then there is a reason for the court to have some suspicion at this particular point of time. Is the child really not a minor at the time that this alleged incidents are referred? This is one submission. Subset of the same submission, first submission itself is that, my lord, the birth certificates that are placed show different birth certificates of this particular victim taken from different entities. So, my lord, there is a great amount of confusion about the age of this particular child with regard to whether she can be classified as a victim. My lord, under the POCSO Act, if she is below 18. So, my lord, this is going to be my first submission. In any event, my lord, that may be a matter for investigation. They may come to some final conclusion about it. But, my lord, the material that is there before your lordships would not be able to rule out that if, my lord, some of this material were to be eventually found true, that this person is not below the age of 18 years age, my lord, then the application of POXO provisions in relation to me, and my lord, subjecting me to any arrest or not being entitled to the grant of any relief may result in miscarriage of justice. And as I said, my lord, the police will come and try to assist your lordships with regard to these various dates that are floating, which to my extent, whatever I could gather, I have placed before your lordships. Now, second submission I am making on demurrer. Not for any reason, if the court feels that at this stage it cannot be decided that the age is above that age of majority, and the court may have to go on the basis that it is a case that may come under the aspect of POSCO, that I am making a slightly different argument. Even if it is a case of POSCO, even according to the victim's mother, who is the complainant, and even according to the police, the child, my lord, is aged about 17 years. If the child is aged about 17 years, and my lord, if I am able to show to your lordships, my lord, from the conduct of the victim and my lord, the circumstances that are existing, that this is not a case, my lord, which would come within the mischief contemplated by POSCO originally. Your lordships will also hear an argument that consent is immaterial if the age is below 18. But I am not even speaking of, my lord, consent being given voluntarily. There is absolutely nothing to show, my lord, that any offence under POXO was committed by me, especially, my lord, the aggravated assault, my lord, that they are now trying to press in relation to me. So if I am able to show to my lords that, my lord, from the complaint file, if those sections are not made out, the aggravated ones, the sections that, my lord, originally were pressed against me were 11 and 12, for which, my lord, the punishment is 5 years and below. My lord, both IPC offences, which is BNS offences, and, my lord, the POXO offences on which FIR was registered are all offences punishable below 7 years of age. My lord, then there would be no need for arresting me. Arnesh Kumar would directly apply. What they do is they file the FIR. They understand that this would not come above the age of, my lord, the punishment of above 7 years. They improve upon that case, my lord, in a statement that they are giving thereafter, leading to an alteration of memo. My lord, for bringing in the section 5 and section 6, my lord, which my learned friend was trying to point out. Now, those are cases, my lord, where offence goes above 7 years. And I am going to show to your ladyship, my lord, a judgment of the Supreme Court which says that if there is an improvement made, if there is an embellishment, if there is an ornamentalizing in relation to a complaint filed, especially with a delay, my lord, then the court would have a reason to take it with a great deal of suspicion. You know, two very, very strong circumstances your lordships will find in this particular matter is, the allegation is, my lord, the alleged relationship started in June. They use the word relationship. They say 2 incidents happened October, November. Last of the incidents they complain about happened on 31st December of 2025. Not very important. No complaint filed, no FIR filed till 8th May. When they filed the FIR on 8th May, the complaint itself specifically says we were weighing legal options to be pursued in the month of March. And when your lordships see the complaint, your lordships will notice the complaint, my lord, is with full clear understanding of all legal aspects. Complaints refers to the law, refers to judgments, and complaint was given on 8th May. If such a well-informed complaint given after 4.5 months, first, it straight away throws in any element of doubt with regard to the correctness and veracity of the allegations made, and I am supported by a Supreme Court judgment directly on this point. Even if, my lord, your lordships want to take it as true, at this stage when I am asking for interim protection, that complaint and the offences that were registered on the basis of that complaint are all for offences below 7 years, which will not require my arrest. If there is, my lord, a buffering and improvement of the complaint that is happening thereafter, my lord, then your lordships might see that there's a clear pattern for the purpose of trying to fix me where I am taken into custody, my lord, for wrongful purposes. Now, my lord, this would be my effort to show to your lordships. My lord, there are 4 incidents that are referred. Each of the 4 incidents I am going to show to your lordships. Prior to the incident and post the incident, there is a bunch of communication, my lord, between the victim and, my lord, the accused that I am representing, which were all very cordial, extremely cordial. The mother comes and says 4 incidents on 4 dates, my lord, and it will take me exactly 10 minutes when I take your lordship through the sequence of, my lord, messages. There were telephone calls for 8 hours, 10 hours, my lord, in each of those relevant periods. And, my lord, the allegation in the complaint is, my lord, I don't want to vilify anyone. My lord, let me, my lord, start with a sense of responsibility that this may be a child below the age of 18 years. I don't want to vilify. I'm only trying to meet allegations where I am sought to be vilified. So, my lord, please understand my arguments where I don't want to make any comments against the victim or any other person, and I'm being very careful. I will not, my lord, overstep my boundaries in relation to any of the state. I'm only placing a few facts for your lordship's consideration, which is with evidence. Each of this evidence I will be able to take before the police and satisfy the police. But the allegation is that I have taken this person from place to place against her wish, and I will show to your lordships around these 4 incidents that the mother complains. It was the person who was picking and identifying the places that they wanted to visit, not for the purpose of, my lord, having any, my lord, penetrative, my lord, the offences that are going to be classified. They were just a group of friends. They were meeting, and, my lord, the complaint itself refers there were 4 or 5 people at each place when they were meeting, and they were meeting together. There is a more serious allegation in relation to 2 instances, and I will show to your lordships pre and post that instance. There is a bunch of material which specifically says exactly prior, exactly after. My lord, they have been in complete, my lord, as I said, conversations which were very, 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 very cordial. So, my lord, for the purpose of consideration of, my lord, now when if I'm able to place this material for my lord's kind consideration, the issue would be, am I entitled to the grant of an interim protection? Normally, your lordships always hear, this is a grave offence. Anticipatory bail should not be granted in a case relating to POXO. I will show your ladyship, my lord, 3 judgments of the Supreme Court, where interim protection granted by the High Court, interim bail granted by the High Court has been confirmed by the Supreme Court. So, as I said, my lord, anticipatory bail is not foreign to this law. Supreme Court judgments say once there is anticipatory bail power, your lordships always have the intrinsic and inherent power to grant interim protection. Interim protection, when granted, never interfered, my lord, by the Supreme Court saying that they could not have granted interim protection. Everything turns on the facts of each case. Now, my lord, I come back to the last question lordships again asked. What is special about this particular case? Lord, my answer is, the facts of this case are special because in the facts of this case, I am going to satisfy your lordships 100% that this allegation and the complaint is completely frivolous. My lord, serious allegations are made against me, which are going to be, my lord, displaced for your lordship's perusal in 5 minutes each. I will show in 5 minutes each, my lord, each of the allegations and say how, my lord, there's absolutely no truth to this particular one. My lord, the lordships have also held in the judgments that if such a case is made out on facts, so, my lord, person is not special. Every case will be decided on the facts of its own case. If in the facts of this case, if I am able to satisfy my lords, my lord, that this is a case where your lordships may have to consider anticipatory bail more seriously. That's all. Then your lordships, my lord, would grant me a limited protection. I am ready to argue tomorrow. I am ready to argue whatever time, my lord, the victim may want to come and assist this honorable court. Till that time, if I am arrested, my anticipatory bail becomes infructuous. So if your lordships are posting the matter at the request of the victim to a different date, my lord, this anticipatory bail must remain alive. But your lordships may not be satisfied in a particular fact situation.
It will become a regular bail.
Your lordships are right.
Correct.
Your lordships are completely right. But what happens, my lord? Now there are 2 hypotheticals. Your lordship grants an interim protection. As I said, tomorrow I can come back and assist your lordships. Any day your lordships want, I can come back and assist your lordships. On that day, when your lordships have the assistance of, my lord, the victim, and, my lord, the public prosecutor should be ready to assist your lordships today also. If your lordships are not satisfied, anticipatory bail will be dismissed. But on that day, if your lordships are going to be satisfied that yes, this is a case for anticipatory bail, my bail must remain alive till that particular date. It can't be because notice has to be issued to the victim. Victim notice is issued. Victim appears through a counsel and says, I need documents. I will place some documents. Post after 1 week. In the meantime, arrest is done. Then anticipatory bail becomes, my lord, completely illusory for me. Lord, I am in your lordship's hands. I have come into your lordship's custody. I want to go into the police station today. I want to assist the police. These seal covers that I want to place for your lordships, I will give it to the police today at 5 o'clock, 6 o'clock, 7 o'clock. But if I go, I won't come out. And if I can't come out, your lordships would not be able to hear this anticipatory bail. They will say, we have taken him into custody. Let them appear for regular bail. But suppose, if I am going to prick your lordship's conscience on the next day, this was a case that your lordships required to give anticipatory bail. Because of the facts of this case, because of the series of judgments, my lord, which I have held, anticipatory bail can be granted in POXO cases, in this kind of cases, your lordships would not be able to undo the injustice done to me. I will never be able to get my liberty back. And this is something the law provides to me. I need to be heard. So, my lord, today, as I said, I understand it's a vacation court. Unfortunately, this FIR was registered in the vacations. Otherwise, I would have gone before the regular court. I would have had 1.5 hours, my lord, to take the complaint apart piece by piece. But today, my lord, what I have done, I have only spoken in the air. I have not shown your lordships the complaint. I have not shown the evidence. Give me, my lord, half an hour before your lordships rise today. I will show your lordships the complaint. I will show evidence, my lord, one sealed cover after another in relation to each of the incidents for the limited purpose of satisfying your lordships today that this matter needs your lordships attention tomorrow, my lord, Saturday, Sunday, Monday, any day your lordships put. I am going to come back before your lordships and satisfy your lordships. But till that, I can't be arrested.
Yes, PP, I would like to ask you a question. Is it true that the first FIR registered, the sections under which the FIR has been registered, sections of offences,
whatever
they are all below 5 years of.
My humble
and
submission.
later on, you have improved. Is it so? If that is the
Yes.
case,
I'm
then
sorry, my lord, some of the material paper placed along with the anticipatory bail petition, kindly see charge sheet, page number 24.
charge sheet is filed.
Yeah, earlier case, what my land friend submitted
About
before
the
this,
age of the
earlier.
victim. Age of the victim.
Page number 24.
24.
Your lordship's question, I am repeating, answer is yes. Every offence was below 5 years.
20, page number 24, lordship got it.
Yes.
11, serial number 11.
Hmm.
After that, CCL Chintala Abi, daughter of Vilas, age 15 years. That is the seems to be my land friend submitted argument.
Yes. Hmm.
This seems to be filed the 2021 crime FIR, Nirmal Town same was registered. Subsequently, final report filed. Whether it is I need to verify. This is the charge sheet filed by the.
All right, that is one aspect of
Yes.
the matter.
Yes.
The other one is the FIR. All of us know that the first information report has to be taken into consideration. In this FIR,
My lord.
the sections mentioned,
My
do
lord.
they prescribe only 5 years or
Or
less than 7 years of punishment?
Initially, at the time of registering the crime, the subsequently same was altered. I filed the 5 and 6, I read with.
May I give the section
minutes.
numbers and offence, my lord? Lordships may just note.
The
also-
was only to move the criminal law, set the criminal law into motion. Subsequently, the very next day, a 161 statement was recorded. There was a complaint. There seems to have been some collusion. They have not recorded the final details and all that. Next day, because of the uproar and the hue and cry made by the NGOs and other organizations, the Chief Minister has taken special interest in this and from the SIT. The SIT habeas officer has come the other day and recorded the entire narration of the girl. The girl cried and told what all had happened. No doubt there was some relationship between them, but that does not mean that that boy can, sleep over her. And then all the ingredients to constitute the offence under section 511 have been made out.
No, my
And
lord.
I have
That's fine.
talked to
Let
that
me,
girl.
yes,
So there
PP.
is nothing like second FIR or anything. It is the first FIR which has been altered the very next day.
Victim,
No.
victim mother came to the PS on 8/5/2026 on 10 o'clock. After receiving the complaint,
Is it a written complaint?
Yes, my lord.
Yes, my lord.
Yes, my lord.
Yes.
Written complaint.
Hmm.
Immediately registered the case. Subsequently, after taken into the statement from the victim, case was altered.
My lord, specific to my lord's question, my lord, the FIR was given on 8th May. Complaint. 8th May, my lord, 4 sections were applied. Section 74, Section 75 of BNS, which is my lord, old 354 and 354A. Punishment is 5 years, my lord, for section 74, and 75, my lord, punishment is 3 years. 2 sections of POXO were added, section 11 and section 12. Section 12 is the punishment section, punishment of 3 years. And I'll show to your lordships. Lord, my learned friend tried to, my lord, in some manner say that there is nothing that happened, some negligence was there in registering the section. If I am able to show to your lordships the complaint, every aspect of the complaint taken to be true, given by the mother 4.5 years, and your lordships will see fully legally advised. The language, my lord, I also was surprised, but I must credit that eventually, my lord, they did a good job, good for them. fully legally advised, and they say in March they took legal advice, they wanted to initiate legal action. So that complaint, today if it can be that in a given complaint a different section arises, section 5 was arising, the police by mistake did not include section 5. I will not have a case saying that police did not include 5 earlier, therefore my lord I should not be today accused of an offence under 5. Complaint, everything taken to be true, 5 not made out. So what they do, they come back with a statement next day, alteration filed on 11th. And my lord, your lordships have held in POXO cases, even 1 day's delay in certain circumstances can be fatal.
No, they said the statement was recorded on the very next day.
9th.
No, my lord.
9th.
Alteration filed on, I agree, my lord. But I'm saying between 8th and 9th, my lord, because 8th they did this, 9th they say statement. My lord, I am told there were 2 statements. At this point of time, my lord, I'm not in a position. One was by the original police paid Bashirabad, my lord, then an SIT was constituted. I think SIT also visited. I don't know which statement they are referring to. But let me take it that the statement is of 9th. 8th, my lord, 8th May, incident is of 1st January. March, they say they took legal advice, they wanted to initiate legal steps in March. So May when they file, and when your lordships looks at the language, my lord, this is not one of those, FIR is not an encyclopedia. My lord, some of those cases, FIR is only giving information, police then, my lord, conduct investigation, come to conclusion. This is a case where FIR itself, my lord, is extremely detailed, legally advised, refers to Supreme Court judgments, indicates what are the cases of harassment. So a case of harassment filed. My lord, graver offences filed against me. They wake up the next day and my lord, they give the complaint, they say the statement is given. But therefore, I am submitting. And my lord, I am supported by Supreme Court judgments which say that there is an embellishment. The words your lordships are used as any embellishment, any ornamentalization, any improvement to complaint. My lord, your lordships will take it with a great deal of suspicion. All that I am saying is today, as your lordships hear the matter, this is a matter, my lord, that may require the consideration of an anticipatory bail. My anticipatory bail cannot become infructuous whenever your lordships hear the matter. But if your lordships want me to discharge a slightly greater burden, I can take your lordships through the complaint, show to your ladyship, my lord, from the complaint how no grave offence is made out, how from the complaint there's a...
No, even on this interim protection petition, I don't want to take a decision without hearing the victim's side. Okay, so if you are ready to advance your argument
Yes.
tomorrow, I'll post it tomorrow so that he can come to
Should I
it.
kindly grant
On
me
that
1 week's
interim,
time?
you want
Why
1
not?
week's time.
No, my lord, 1 week, then the police will arrest me, my lord. I want to join the investigation. I want to go
That is
today.
all a bullshit story. I'm sorry to say that.
This is not a
Please
language we
don't
use in
use
the
such
court. I'm
language.
sorry, my lord. We must
Sorry.
maintain the
Everybody-
decorum.
I'm extremely
Nobody
sorry.
supports any incident of this sort,
My lord, once
but using such
I would,
language is not.
I would take back my words. I would say it's a cock and bull story. It is not right what they are saying. My lord, one submission. For a minute, your lordship may kindly see the complaint which has generated from me. Paragraph number 6 of the complaint, page 17. For a minute.
No, I'm asking you if you will be ready to argue on the interim application that he's asking, even before the anticipatory bail is
What I respectfully
considered.
submit is, my lord,
So if-
even in the application of opposing for simple reason, the father of the boy is the Union Minister for Home Affairs Minister.
My lord,
Just sir, please sir, if you have not concluded, just if you finish, then I'll argue. I don't want interruption in between.
You may continue. Yes.
I think that.
All right,
let me
his
take a seat.
father is a minister, so
Well, the father is a minister of state. And then, my lord, your lordship will be surprised. On the evening at 6 o'clock, I go to the police state, Bashirabad, to lodge the complaint. Till about 10:30, don't register the case. They pass on the information to you. And they wanted to show that there is a counterblast to this case. They go to Karimnagar and lodge a complaint on some extortion saying that 55 lakhs they are demanding just to show that it's a counterblast to this case. So how influential are they, my lord? And what is
now
that
what is this
influence?
girl doing?
She
No,
is a student, my lord.
so what about her birth
I
details?
really do
date
not
of
know
birth?
the finer details.
So
That
get the
is why
details
I'm
by
only-
tomorrow. The police can do the verification.
My lord, I should be given
Why
some
there are,
time
he
to
has
find
filed
a counter.
two
My lord,
date of birth certificates.
My lord.
One is of 2008 and one is of 2010.
My lord, even
So
assuming
how can
either
that be?
2008 even
Two date of
assuming
birth.
2008 is correct or 2010 is correct, she still is a minor below 16 years of age.
No, but then there is a charge sheet which says she was 15
No,
years and
correct.
2021.
Determination
So all
of
these
age.
things, the
My
police
lord,
can do the
determination of age
verification
as
and
per
come
Supreme
tomorrow.
Court, the law
Yes,
later
ma'am.
on is.
Yes, ma'am.
I have already
conclusively-
heard you, sir, with regard to your interim application.
My lord,
You are
Only-
opposing it. I have heard you
my lord,
also
your
with regard to
lordship
the
may kindly
interim
grant me
application.
some time to file the counter.
Yes, yes,
And I do
anticipatory
not have
bail.
much material, and let them file those 161 statements and 161 statements, or let the public prosecutor serve us.
I'll pass orders on this interim application tomorrow, and the anticipatory bail will take up next week. Okay? Only on this interim application, whether any interest protection is
My
to be
lord, your
given or
lordship
not, I'll
may
pass.
kindly see the contents of the complaint for a minute at least. What my learned
I'm not
friend-
allowing it,
No,
sir.
no, but you're saying your lordships are going to pass orders.
Orders on this IA 1 of 26. He says there should be interim protection even
So,
before the
your
anticipatory.
lordship asked him only
So-
one question. One question. How is it that you are special from others as far as?
So do you think I will not be considering it while passing orders in IA 1 of 26? I have to dispose of this IA 1 of 26.
No, no, then
Either-
everybody, why are all others are not?
So
entitled
why are
to
you
the-
presuming that I have allowed it?
No, I'm not saying
Then
that. I
I'm going to
never-
pass orders
I'm
tomorrow
only
on
saying-
IA 1 of 26.
May,
No,
Okay.
How is it that his application is separate from all other applications?
All right, that's
And
what I
the
have asked and
convention-
he has answered. You also
convention-
submit your.
The convention of this honorable court, your lordships are very well aware of. Any application which is coming for the first time, fresh matter, is automatically go for 1 week. And that too, now what is the urgency? Now he is absconding. He's not in jail. It's not that he's in illegal custody. What is the urgency? And why is it that I'm being forced to argue only tomorrow itself, even without going into the
I'm not
material?
forcing you to argue
No,
that
but my
bail
respective
petition
submission is, my
tomorrow.
lord, your lordship may kindly grant me some time.
So you want time even in IA 1 of 26 also?
That is not different from the main application. That is what I'm saying.
All right, I'll
but then,
consider that.
my lord, may make one. Because my friend didn't want me to interrupt him and he was right in saying, so I thought it's better that I keep my arguments till he finishes, so I reply. My lord, first submission in relation to what my learned friend argued. My lord, your lordships have not heard me in relation to this being a counter blast case. I have not referred to any fact. I simply said, even if the complaint as filed by the, my lord, my learned friend will now give me the same
If you are
custody.
both-
I'm sorry.
If you are both going,
Yes.
no, see.
But he must have the same rules that he wants to set for others, my lord. Once he said, please don't interrupt, my lord, I kept quiet. I said he was right. He was right in telling me. He was correct in correcting me. I corrected myself. Now let my learned friend not, my lord, make a mistake that I had made earlier. First, I had not referred to, my lord, this being a counter blast case. I understand that when I argue anticipatory bail, I will have to argue my case at a greater detail. For the purpose of interim protection, today, my lord, I said, I will assume everything said against me, which is, my lord, in the complaint filed by them on 8th May. And I, my lord, also said I will take the burden of, if necessary, showing to your lordships the entire complaint, and from that complaint, no graver offense than punishable more than 3 years is made out. Only sexual harassment case is made out, which is 3 years. 8th May, your lordships asked a specific question to the learned public prosecutor. Did the complaint as filed originally have offences below 7 years? But the learned public prosecutor fairly could not contradict it, though he did not admit it, because he understands this is a sensitive case. Everybody wants to be sensitive about this. But second submission, that I take serious objection to my friend stating, my lord, and saying that we are trying to be special and there is a convention in this particular court. My lord, I would respectfully bring to your lordship's notice, I started my argument saying that there is no bar for grant of anticipatory bail in law. There are Supreme Court judgments which say that if the court has the power to grant anticipatory bail, it has an inherent power to grant an interim protection. Third argument I made, this honorable court has concurrent jurisdiction to entertain an anticipatory bail. So I placed it, my lord, on the ground of law and the Supreme Court judgments. I did not place it on any special right that I claim. I in fact said, my lord, I am no special. If I am special in something, unlike any other person who is accused, my lord, they will not be vilified in social media and posters will not be put up all over the city. My posters are put up all over the city. I am vilified. I am made a villain everywhere, and political parties carry out rallies against me. Have your lordship seen this happen with any other accused? That is where I am special. I am special where I will be victimized. I will be punished even before your lordships render justice to me. I did not come and make a complaint because of all these things. I need protection from the court. I understood that is a part of my fate. My father may be in politics. Some things are good, some things are bad. This is a bad thing that will happen to me because my father is popular leader. He is someone who is popular in politically. I did not make that particular case. So for my friend to refer to my father and try to say that, my lord, I am trying to use any political influence was wrong in the context of the limited argument we are making before your lordships today. But I come back to this one request. I am ready to show the complaint, my lord, in the next 15 minutes. I will show this evidence one by one and I will assist your lordships. Now I am arguing, my lord, from an interest of justice perspective. One, I do not want the anticipatory bail to become infructuous, number one. Number two, I don't want, my lord, the investigation to suffer. I want to join the investigation today. I am requesting your lordships, grant me limited protection. I will go, I will appear before the police, I will give them this material, the police will understand all of this, the police will know whether they would want to arrest me or not. Merely because offence is above 7 years, so lordships have clarified in Supreme Court. Arrest is not mandatory, 41A old. It is only if the police feels, my lord, that below 7 years, my lord, if they want to arrest, they will follow a procedure. Does not mean if it is more than 7 years, it automatically, my lord, has to be arrested also. I am sure that, my lord, if my learned friend at that particular, he had been a public prosecutor at one point of time, if the police come to him with this evidence, if he was an objective, a public prosecutor, and I'm not putting the burden on him, he would have. ACB standing also, I'm sorry. But my respectful submission is, I really want to assist the process of law. And my lord, I do not want, I'm only saying, my lord, I'm ready to argue my anticipatory bail today, which I cannot insist, because I realize I am not special, though my friend may think I am not. I understand the victim will have to be heard and the victim may have to be given reasonable time, and my lord, I fully recognize that. All that I am saying is, by your lordships of protecting one victim, let me not become a victim in the process. I need protection from
I'll consider and pass orders, either accepting your request or rejecting your request tomorrow. In IA 1 of 26, I'll pass order, and bail application will be decided after a week. So I'll post it next week.
But then may just
tomorrow it will be
may then
Our
just
learned
yes,
friend is relying only on a limited material which is available at the preliminary stage. Subsequently, the lot has gone, lot of water has gone under the bridge. So where is that material? Let at least the public prosecutor supply us with the material. Today there was a 161 statement recorded by the magistrate. It's going on. And the 161 statement of the SIT in charge IPS officer has been recorded. Where is that? That will reveal the real truth. And what my learned friend is saying that our influence on the complaint is incorrect.
It is, my lord.
All right, sir. I think both of you are repeating yourself again and again. I know your anxiety, but don't pass it on to me. I will not be
Very well, madam.
Yes, madam.
Okay,
But,
it will be taken.
may
tomorrow.
just only for the purpose, I'm not arguing anymore. My lord, there are 3 Supreme Court judgments where an interim protection granted. My lord, Supreme Court sustained it. I'm just giving those 3 judgments. I'll give copies to
I
my
have
friends.
more than dozen judgments rejecting the POSCO cases, remanding the matter to the trial court.
There are
POSCO
cases
case should
both
not be
ways.
taken.
Very mood.
There are cases both ways. There is no,
Madam,
there is,
that-
there are no,
that cases are
no,
altogether
1 minute.
different,
Yes,
my lord.
each case has
Sorry,
to be
I've been
considered.
practicing on a criminal side for more than 30 years. My respectful submission is those judgments what my learned friends are referring to are the different situation altogether.
Very mood change.
They
Every
are
case,
altogether a different situation.
every case will
Not
be,
such graver offences. my
sir,
lord.
if you are going on.
I'm sorry.
with this-
I'm sorry. I'm sorry. I'm sorry.
Every case is distinct, and the facts of each case will have to be looked into.
Very well.
The judgments which he refers to will also be looked into on the touchstone of this case, facts of this case. So rest assured that all the factors will be considered and passed orders.
But all the 3 cases that I'm giving to your ladyship are under POXO. One of them is under section 6, which is the same section which is later sought to be improved, not originally put.
You also saw
Yes, my lord. I'm giving, my lord. So all the 3 judgments, my lord, that I'm relying on are granted interim protection by the High Court, maintained by the Supreme Court in POXO cases only. And my lord, there are at least 7 or 8 High Court I'm not placing there.
So tomorrow, yes, call the next case.
My lord, your lordships have concluded the arguments, or your
In
lordships?
IA 1 of 26, your arguments have been concluded. You want to advance any further arguments in IA 1 of 26?
Yes, my lord, I'm not at
All
all
right,
prepared.
then
I
I'll
don't
hear.
even know anything. So
All
Lordship may kindly permit me to argue the matter tomorrow morning at 10 with regard to this interim application.
Interim
of my
application.
learned
All
friend is
right, I'll
seeking
hear
for.
him also and pass orders tomorrow.
And your lordships would grant me also, my lord, because I.
Yes,
if my
yes, you
learned
want to
friend wants-
appear in person or virtual, you can do it. Yes.
But, because of the pressure of your lordship's board, can it be higher up on the board, my lord? Because as I said, we want to go and join investigation as early as possible. Even if it's a
on, I
bail
think-
matter, it generally comes higher up.
Every second criminal will come and say that he wants to join investigation.
But I take very strong objection, my lord. My learned friend is a counsel. He cannot categorize anybody as a criminal.
No, one
I am
minute.
sorry. I am sorry. He appears for several persons
No,
who are
whoever
accused.
may be, please.
Graver offences.
No, please.
I'm sorry, I had a been.
Whoever, no, please. Mr. Please,
Sorry, ma'am.
none of you will raise your voices
Yes.
in this court.
I am-
If you are want to, do it, then I'll recuse this
No,
one
no, no,
case.
no.
Let it be posted before another bench.
No, I'm sorry.
No problem.
The only thing is.
No, you have to maintain the decorum of the
My
court.
lords are right.
You
but
can't raise your voices,
No, no.
and one of the principle is a person accused, that's the reason why we call them accused. He is
Correct.
only accused of a charge. Unless proven guilty, he is presumed to be innocent. So you can't say that, so and so is so and so. Please
No.
restrain yourself, you yourself are a public prosecutor or
I was never a
prosecutor,
public
not a
prosecutor,
public
ma'am.
prosecutor, maybe ACB counsel or whatever.
a special-
So all of you are senior counsel, you know the law, you know the principles. Don't get, personal
Correct.
with anything, any case.
Anticipately there, my lord, it is so. I don't
No,
know.
see, we should not
Very
get attached
mysterious.
with, your client. You are a counsel, that's it. Please be a counsel.
Very well.
Yes.
Deeply grateful.